It's there now.
Okay, good, thanks. All right, here, I'm gonna get that out of the way. Okay, so this is making sound decisions. So our last segment focused on the land use review process. This is focused on what the end of that process should look like. And the decision is sort of the final result of the planning board or zoning board process. And it's extremely important to get it right. Let's see. So this is sort of the concept.
Carolyn, this is Andy. Before you go on, you might want to reintroduce yourself, remember?
Oh, that's right. Thanks. Hi. Well, I'm Caroline Wells. I have been a planner for about 20 years. I currently work for Weston and Sampson in their urban environmental planning, but most of my background is in municipal planning. So Andy Tites will be taking over shortly, and he is a solicitor and planner for many municipalities. So I'm just going to kick us off here. You can see the content of the workshop. We're going to go over the goals, the legal power and responsibility, the land use review process, and then we'll give you some more information, resources, and additional training opportunities in case you want to learn more. And of course, you can also contact any one of us, and we can also give you some more resources. The whole workshop is sponsored by the Rhode Island Land Use Training Collaborative. Special thanks to statewide planning and the Federal Highway Administration. But it's really a group of both public and private supporters who work to provide this education so that our boards and commissions can really create the best decisions and the best land use processes that we can really get, and that's going to save us both money and time later on. The goals of the workshop are, number one, to understand the importance of the decision, but number two is that the decision is actually comprised of a number of different components, and that's what Andy's going to really get you into. The third section is to gain practice writing a sound decision, and although boards and commissions often don't write their decisions, that's usually something between the staff and the attorneys. You should be able to recognize all of the components of the decision. You should be comfortable weighing in if you believe the decision doesn't really accurately reflect something that you said or you believe was part of the board's decision. And also, number four is to be able to apply different standards for the application review. And by standards, we mean standards from plans and ordinances and other regulatory guidance. So what are the traits of a key sound decision? Number one, it should always be clear, rational, logical. If you're reading a decision and there's something unclear as a layperson, you probably want to bring that to the attention of staff because we're all human and mistakes get made. So the point is to have a very, very clear and accurate representation of the decision that the board made. It should be professional. So oftentimes boards are lay people. We understand that you have full-time jobs and families, and this isn't your background. And also there are numerous pressures that are placed on board members. We talked about that in our last section. You go into a coffee shop or you find people in the grocery store and they want to give you their opinion. But as a professional board or as a board member, you want to be professional at all times and sort of be above the emotion and the politics that can often take place at the local level. You also want your decision to be legally defensible. So it does require that you know what your comprehensive plan says or what the ordinance are in your zoning ordinance. You have to be able to understand that every standard that you're holding in your decision should relate to some standard that's actually written. So it does help to have all of those documents. If you don't have those documents, you should be requesting it from staff, or you should have access to it readily so that you can have it with you when you're reviewing an application. So being in a board, like a zoning board and a planning board, is a legal power and it is a responsibility. And You'll hear your staff members likely say this over and over again, that we work in the public interest. And that has a specific definition of the individual versus the community welfare that we talked about in the last section. We're thinking about the community as a whole. And so sometimes if you are very familiar with an application, it does help to step out of it just for a bit and try and regard it as a general public member, as a sort of check on the process. Am I doing everything I can to accurately reflect the public interest? And you can also look at your comprehensive plan and your zoning ordinances, which were all approved by public bodies. So those are representations of the public interest written down. So once again, the public interest is, it's a specifically defined term, but it's also, we talk about the spirit of public interest. When you are faced with decisions either on the board or in the general public, in your mind should always be, what is the public interest here? Because you are acting on behalf of your community. So as a board member, you have this special responsibility. You have the ability, well, some boards have the ability to adopt plans. Other boards have the ability to recommend, say, to their town council or city council that they adopt a plan. So you do have an important responsibility to make sure that the plans are clear and professional and accurate as well. If they also reflect what you've heard in community meetings or in discussions. Also, you have the responsibility to enforce regulations. This is not a case where it's really up to you to bring in outside information. Your regulations and your standards are really your guideposts for your decision making. And you also have to ensure that property owners have met the standards. As was discussed in our last session, if somebody has an application but it is not meeting one or more of the standards, then you have to really discuss that and come to a conclusion based on the standards and not any other opinions that might be coming up. But that is often much more difficult than it seems. So I'm going to hand it over to Andy to talk more detail about the actual decision, crafting that decision itself. So I'm going to stop sharing my screen.
Okay, this is Andy Tites. I guess I need to introduce myself first. If it appears like I'm not looking at you, please forgive me. It's I got it's first time I've actually not used the iPad, but using a full screen computer with a separate camera. Anyway, I am an attorney and an AICP planner. Our firm represents 5 communities in Rhode Island as town solicitor: Bristol, Barrington, South Kingstown, and the Greenwiches. And for most of them, for 4 of them, we've been their solicitor for over 25 years. So we try not to be partisan. We basically call it the way we see it. And that's my goal here today. We're trying to help all of you with your jobs, both the paid planners among you and the volunteers as well. But I've had a lot of experience sitting on your side of the table and also represent developers in the other 34 cities and towns. So I've got that experience too. And I was involved in the early 90s in the writing of the land use statutes. So that's kind of my background and biases in the presentation here. And I've been doing the training for about 25 years or more as well, back when it was the Division of Municipal Planning Assistance, later with URI stuff, and now with GrowSmart for a long time as well. So with that, I'm just also going to note that one of the goals there was to practice actually doing a decision, and we're not going to have that because of the virtual setting we have here today. Unfortunately, COVID-19 prevents us from having a hands-on exercise. When we do this in person, we literally roll out the plans on the table and have you practice doing an actual decision, which we really can't do virtually here. But we'll do everything up to that point and beyond it. So let me take a moment now to share my screen and hopefully pick up where we left off. So share. Okay, and I'm going to play from current slide. Okay, so Caroline or CJ, are you seeing the slide here?
Yep, looks great, Andy.
Okay, thanks. Let's move this out a little bit out of the way. So we've got the first thing here is talking about the sources of your land use powers, coming from the federal government, the sovereign, going back before that, before the revolution, to the King of England, but now in the Constitution and the laws of the United States, and flowing through the state of Rhode Island, both some of its inherent powers as a state within our federal system and delegated powers within the federal government. And there are several acts. We talk about the three main ones are the Comprehensive Planning Act from 1988, the Zoning Enabling Act of 1991, and the Land Development and Subdivision Review Act, which is also just called the Development Review Act from 1992. And that was a major rehash of all of the acts that basically tried to get them to coordinate among themselves. So for example, the acts, all the definitions in each act apply to all of the other acts, and then it flows through there that your zoning ordinance is supposed to be consistent with your comprehensive plan, and so forth. This flows down to municipal side. You have your town charter, then you have your local documents. You have your local comprehensive plan, you have your local ordinances, your zoning ordinance, etc. And one of the things that's just thrown in under municipal regulations, I want to stop and talk about, and that's appoint board and commission members. That's generally in most places the role of the town council, or in some of the cities, it's combined, appointed by the mayor or the town administrator and confirmed by the council. But that's actually, in real life, one of the most important things on this page and among the powers of a city or town council is appointing the board and commission members. I can't tell you how many times I've had a council member come up to me after a meeting where some board member made a vote that could be charitably described as stupid and said, "How does that happen? Why can't you do something to stop it? Can't we amend the ordinance to stop that?" And I try to tactfully point out that that same council member appointed that same board member only a few months before, or reappointed them. And I know it's hard to get volunteer board members, and that's the tendency. You just reappoint the same people who want to be there. There's also political pressure. And by the way, all this doesn't apply to Charleston where they're elected, but in all the other cities and towns. It's very important that the council try to get good people for the boards. And to you who are board members already and professional planners in your communities, I say to you, that's one of your most important roles. Recruit people, go out and find people. You meet people, new people who've come to town who have skills, interested in the community, or people who've been around and always saying, gee, I should get more involved. Go out and recruit those people. Try to get them to apply for these openings and get good people to the boards. Because all the other stuff we do, I won't say it's worthless, but it's only about half the job if there aren't good people who care on the boards and commissions. And they don't necessarily have to be trained. They don't have to be experienced lawyers or planners. They just have to be people who care and people who are willing to learn. So that's my little speech there. I'm going to go on to boards and commissions. That's the next level down from the municipal, the actual boards themselves. So let's go on to the next screen if I've done this correctly. And it's not advancing on the, let's try a different thing. There we go. Okay. Sorry, I mostly use my iPad rather than a computer, so I'm not sure of the buttons. Your legal power, we talked about this broadly. The 3 acts on the left there that are the most important ones. There's a variety of other ones that have to be considered as well. 2 of the most important. By the way, now I'm moving the mouse. Can, if someone, CJ or Nancy is, or Carolyn, is the mouse moving over to historical area zoning?
Yes, it
Yeah.
is.
Good.
Yes.
Okay, good. So I have a pointer. So historical area zoning, that's one to remember for those with historic district commissions, that there's actually a separate zoning enabling act for historical zoning and historic district commissions. And by the way, it's the oldest. It dates back to the 60s, and it really needs a comprehensive overhaul, but for a variety of reasons, it hasn't happened yet. I also want to call your attention to the bottom one here, Chapter 45-53, Low and Moderate Income Housing, also sometimes called affordable housing. And this provides a one-stop shopping process for affordable housing developments under a process called comprehensive permits. And it also has different standards. We're talking about the standards for decisions, and we are not going to go into that for low and moderate income housing today. That would take a whole couple of hours itself. Just know that there are separate standards when you're considering a comprehensive permit for low and moderate income housing. And what's really different is we'll talk about in a minute how for the rest of these standards, to approve it, someone's going to meet all of the standards. And if they don't meet all of the standards, you need to deny the application. For that particular chapter with low and moderate income housing, they're asynchronous. There's one set of standards to deny and another to approve, and they're different. So you just need to know that you've got different standards, that you can't simply deny because they don't meet the standards to approve. There are different sets of standards for low and moderate income housing. And, sorry, next one. Due process. Some of this stuff may be a little bit of a repeat for those of you who are here this morning also. But since we know that not everybody was going to do both, we do have a little bit of overlap. A set of established principles that assure fair treatment. They ensure that government does not abuse its power by acting in an arbitrary and capricious manner. And these are kind of broad words, and I guess the real question is, well, what does that mean? This is where we should have Nancy's Spider-Man logo popping up here too, which says, with great power comes great responsibility. And this is where I'll just remind you that most people don't have much contact with their government, and their local government included. You know, maybe they go into town hall to get their dog license renewed or pay their taxes. But sometimes their only contact with government is when they get one of these notices in the mail. Some neighbor has applied for a subdivision, or some neighbor has applied for a zoning variance. And they come in and they have no idea what to expect, or they Zoom in or they call in, and realize what I like to say is, to them, you're the man, you're the government, with all that implies with the government, the quotation. And no, it's not the same as tear gas in the street, but it still has an impact. If your board is rude, if your board leaves someone with the idea that they didn't even get heard, then you're creating that bad feeling about government as a whole. It's not saying you have to just do what the majority want all the time. In fact, you can't. That's what this whole afternoon is going to be about, is following standards and not necessarily what the majority of people in front of you want. But you need to make sure that everybody who comes before you and has the right to be heard under a public hearing can feel that they had a meaningful opportunity to be heard. Amy added that word this morning. It wasn't in the text, but it is important. It's got to be a meaningful opportunity to be heard, that they believe that you actually listened to them, even if you came up with a different conclusion. Two types of due process which lead to that are substantive, which says based on law, and that's really what we're talking about here, going to be talking more about here this afternoon, is the standards, that you didn't base your decision just on the fact that there were 50 people against the application and 5 people in favor of it, so therefore you voted against it, or vice versa, that you based it on standards in the law. And then the second one, procedural, that people had notice of the hearing and an opportunity to be heard. And that was pretty much covered this morning. I'll just note it's also based on law, despite the fact that we don't use those particular words there. Procedural due process is based on law. It's based on the 5th and the 14th Amendments of the United States Constitution. So, but it's concerned with that notice and the opportunity. Was the process fair? Is the first part procedural due process, and substantive due process, was the decision actually based on these standards? Next. So we talked about individual responsibility and public responsibility, and this is more of that. You have the individual's rights, that the individual knows what's going on and has that opportunity for the comments. And then you have the community's rights. The public is a body that can be considered as well, and what's in the public interest. And through much of your work, that's going to be looking to the comprehensive plan, because that is the community's embodiment of what the public considers important into how its community is going to develop. Providing all interested party with the opportunity to be heard at a public hearing that's fair, open, objective, and impartial. Make the decisions standard, and again, the comprehensive plan. So, qualities of sound decision, timelines. Now, I'm not looking. I don't know. CJ, are there a lot of questions building up? Do we need to stop now, or should I keep going on before we stop for questions?
No, keep going, Andy. We'll hit the questions during Q&A.
Okay, all right. So, qualities of a sound decision. There are timelines in which you have to make a decision. If a decision is just postponed and postponed as well, that's not due process for anybody. There's a weird thing in Rhode Island law. I don't want to get too legal with you, but I got to take this little side jaunt into timelines that are directory versus mandatory. And you won't find this written in the statutes. You have to read the cases. But what the court has said is, if there's something in the law that says, with variances or special permit, that this decision shall be rendered in 15 days, or appeals in 65 days, even if it says shall be, that is a directory standard. If there is not a consequence of not meeting that timeline, then there's no consequence. It's just directory. It's, you should do this, but there's no consequence. The only remedy is someone can try to go to court and get a writ of mandamus to force you to actually take the action. So, for example, in most of the zoning board stuff here, there's no consequence. These are directory to the zoning board. These are things that you should do. Whereas when you get to the planning board, almost all of these have consequences. If you don't certify a decision complete within the time frame allowed, then it's certified complete by default. If you don't make your decision within the time frames that are up before you on the screen here, then the application is approved. It's deemed approved. This is a consequence of the actions of certain communities in the late 1980s and early 1990s that basically their decision was to prohibit development by delay. They were just never going to decide things. Rather than amending their ordinances and say, okay, this is what we want and this is what we don't want, They just didn't make decision. So as a result, this act passed in 1992 created these timelines and said, if the community doesn't act within these timelines, the decision will happen by default. So these are mandatory timelines. Almost all of the timelines in the Subdivision and Development Review Act are mandatory. All the timelines in the Low and Moderate Income Housing Act are mandatory. Almost none in the Zoning Act are, and one is in the Historic District Enabling Act. So I'm not going to really, go through all the timelines at all. Just know you can ask the applicant to agree to extend the time, but they don't have to. So if you're working on these timelines, you should always make sure you have them in front of you. We think a good practice is actually on your agenda, particularly for a planning board. When you have this stuff here, you should have, like with each agenda item, when was the last action, and thus when's the next timeline going to run. So it's right there on the agenda as you're looking at it. And also, if you're continuing them, don't continue it just, oh, we'll move it a month out, because some months are 31 days, your meeting's going to be the next day. Make sure you're looking at your meeting schedule when you continue something to a future time frame. So we're talking now more about, we're talking about when you made the decision. Now we're talking about qualities of a sound decision. Clarity and completeness. Clarity is always helpful to have as you're going forward. Clear decisions are more easily followed. You can enforce it. You want it to be able to be read by the board. We've got a good example there on the brown part in the bottom. I don't know if we have anybody on the phone here anyway, but I'll just read it. This condition from a zoning variance. The board granted the request for a variance to construct a 2-story, 10 by 22 foot addition, a full second floor addition, and a 12 by 14 open deck addition closer to the front line. 25 feet required, 9.2 feet, and 10.5 feet requested. And the question is, if you're the enforcement officer, what do you enforce here? This tells you what was requested. It doesn't tell what was granted. Now, some of this could perhaps be taken care of by having stuff, in accordance with the plan submitted. Even then, it's important to make sure you pick up on in accordance with which particular plans, because oftentimes there are a lot of plans over time. Sometimes plans get amended at the hearing. Well, the deck is too big. 12 by 14 is too big for the deck. We're only going to grant you 12 by 8 feet on the deck. And I think Amy mentioned this morning. One of the things you should do in that point is, if you're in person, have the applicant come up with the red pen and cross it right off the map at that point and initial it. If you were doing it virtually, it's got to be made clear for that in the record. And as we're talking about here in the decision, somebody's got to make that note at the time the applicant, the board says it or the applicant offers it. Someone's got to be tracking that note to make sure that when you write the decision, it says that. And, a 12 by 14 foot deck was requested. What was granted was, and even 12 by 8, does that mean that the 14 got chopped to 8? Or does it mean that the 14 got chopped to 12 and the 12 got chopped to 8? So, say it specifically, a 12-foot wide deck by 8 feet deep. Make sure you're talking to someone as if they couldn't necessarily understand it if they can't see it, because they may not see the plans that you're looking at. By the way, as far as wishy-washy conditions, my least favorite, I was going to say my favorite, but I guess I'll not say my least favorite, is when a board requires appropriate landscaping. If you're going to put that as a condition in the decision, appropriate landscaping, don't even bother, because nobody is going to know what it is. Make sure it's specified one way or another. Offered by the applicant, if it's in a plan, reference a plan, or if you're having to do it on the fly, if you can't continue the meeting for another day to get that in, you have to do it on the fly. then at least do it on the fly specifically. A row of arborvitae spaced 3 feet apart and at least 3 feet high at time of planting. Something specific that people can follow in the future as they're going forward. So let's talk about some more of the specifics of the decision. Clarity and completeness. Keep it simple, stupid is one of my 2 mottos. KISS. And the second one, which I have to admit is a bit contrary, and you have to balance them, is tell the story. Explain why you're doing certain things. Lawyers get criticized a lot for putting whereas clauses in documents, but that's really the idea. The whereas clause is not supposed to be just a recitation of formalities, but it should tell you the story behind what's being done. So don't be afraid to tell the story. You know, in the last example, when I was talking about the deck, don't be afraid to have in the decision. The deck was proposed at 12 feet wide by 14 feet deep, but we find that 14 feet deep would be far too close to the neighbor and infringing on their policy, on their privacy, and therefore we allow a 14-foot wide deck, but it may only be 8 feet deep. So then there's an explanation. It helps to understand. It's great for a future enforcement officer, and it's also good for the people, even the applicant, knowing why you did it. It's not just arbitrary or capricious. We suggest here using bulleted points rather than full sentences. That's fine too, if it helps you. Keep your sentences short. That's good. I recommend reading early Ernest Hemingway if you find you're getting too long and wordy with your sentences. Review the writing for clarity, have someone else do it, and if possible, revise for fewer words, but don't do that at the expense of telling the story. Defensibility. Strong, thoughtful reasoning based on standards, clearly articulated findings, well-written decision, defensible. You've got to be able to defend this. And I want to just say, this isn't just for the benefit of your city or town and its legal budget and not having to pay to defend these things. And also, there is a law in Rhode Island that now provides for attorney's fees. So if you lose one of these cases and there was absolutely no basis at all for the decision, not only are you going to lose, but you're going to pay the other side's attorney's fees in a lot of cases. So that's one reason. But also, for the objectors or the applicants, whichever side prevails, the worst thing that's going to happen is the delay and whatnot. You know, you may think cutting a corner may be helpful. It's a good project. Everybody is in support of it. It's important for the town. It's okay. But you're not doing the applicant any favor, because if it's not a defensible decision, then it's going to get overturned. If you've made a procedural error, if you've made a notice error, it's really bad because it could get overturned after something's already been built. But even without that, there's the concern about, you think you're going to save the applicant a month. He doesn't have to come back next month after you've fixed a procedural problem or you've gotten a better decision. And then you go ahead and you got a weak decision and someone appeals it and it goes up to the court. And even if the court doesn't overturn it, but simply remands it, that's probably going to be a year later. So in order to save someone a month's time, that's what you thought you were doing them a favor and saving them a month's time. And in fact, now they are a year and a half or 2 years later. So that's important to remember. The next 3 pages have some various procedural stuff. And this is very important. So I'm going to read every word of this screen as we go forward. Just kidding. I'm not. I wish, unfortunately, I can't even see any of your reactions. I hope you were laughing. But I just want to hit the high points here. Basically, the question is, your decisions need to be based on standards, and we're going to talk about that later. And I'm not going to read all the standards to you now, but I'm just going to point out, and this thing's going to get emailed to you afterwards, so you'll have the reference. So if you're a zoning board and you're handling a dimensional variance or a use variance or a special use permit, and this says review of a zoning official's decision, but actually it should be appeal of a zoning official's decision. But so these are some of the standards. So the ones that are shown here on the page, they don't apply to an appeal of a zoning official's decision, but for everything else that a zoning board would do, dimensional variance, use variance, special permit, this is your Bible. These are your standards. And by the way, this particular one here on this slide, when you get it, you've noticed it's a quote from the state. It's taken right out of state law, except some of the stuff is highlighted in red and underlined and added numbers. And that's my doing. This is my annotated section. If you just took a quick glance at the statute, you'd say, oh, there's 1, 2, 3, 4, plus another one. There's only a total of 5 standards here that we have to meet. But in fact, when you read it clearly, a lot of them are doubled up, and there's actually a total of 9 different standards that you have to meet, with that 9th one being different depending on whether it is a use variance or a dimensional variance. So it's important. This is probably the most important thing, I would say, that you need to have, and this is in these making sound decisions. If you're a board member, this is what you've got to do. If you're a zoning board, it's on this page here. Now, I'll just note that if it's an appeal of a zoning official's decision, you don't have standards like this. The standard is you put yourself in the place of the zoning enforcement use officer. You stand in his or her shoes. You hear the evidence, you get to hear evidence, and you can substitute your judgment for the zoning official if you're a zoning board hearing that. That's the one exception to all the rest of the stuff that we're going to do about appeals. But if the zoning board, zoning officer, your building inspector is often your zoning officer, but the official title is zoning enforcement officer. If you're hearing an appeal from him or her, you get to basically pretend that you're him or her and make the decision that you think would be right based on the underlying standard, what's in the definition section of the ordinance or the use table, et cetera, whatever is being appealed from. So then we go on to the blue side, appeals to Superior Court. And these are the same actually for all the rest of them, and we're going to talk about. And the Superior Court is going to hear the appeal on the record, based on that record that was developed on the zoning board, and they're going to determine it based on that. And if you look in that, well, it's hard to see here, but it says the court shall not substitute its judgment for that of the zoning board of review as to the weight of evidence on questions of fact. And we're going to get into that more detail, but that's the key thing. It's that it's on the record. It's not substituting the judgment. And then finally, if someone wants to take something to the Supreme Court, they have to ask the Supreme Court to hear it. You may have heard of the term writ of cert. It's short for the Latin writ of certiorari, but basically that's a procedure where you ask the Supreme Court and say, hey, I think the Superior Court made a decision on this that was wrong, and you also generally have to either show that it was like really wrong, or it has broader consequences to get the Supreme Court interested in taking your case, but it's totally up to them. They can decide whether to hear it or not. And sometimes it's very disheartening to get a one-line response to your carefully crafted petition for a writ of cert that just says, petition for writ of cert is denied. But that's the way it is. So don't count on stuff going to Supreme Court. In very rare instances, cases could go to federal court, but I'm not going to get into that today. Next is, if you're a planning board, what are you doing here? Again, same thing. The stuff on the left in the yellow, that is your Bible. Those standards, 1, 2, 3, 4, and 5, those are what you've got to find. That's where you need to review and make sure the decision complies with that. So that is the important thing to follow. If it gets appealed to the Board of Appeal, which is your zoning board sitting as the Board of Appeal, it's basically similar to if it was a zoning board going to a court, it's the Board of Appeal shall not substitute its own for that of the planning board, but must consider it on the record. And then if it gets appealed again to the Superior Court, the Superior Court's applying the same test, only on the record of the Board of Appeal, as the Board of Appeal was considering the record of the planning board. There was a very good statement, a decision just a couple of weeks ago from Judge Leach on a case in Bristol, the Enright case, where he talked about, and he quoted other cases, that's referred to the funnel, basically the mouth of the funnel. The planning board's the wide end of the funnel, narrows it down. There's less that comes out at the Board of Appeal, and there's even less at the very narrow end of the funnel where it comes out and gets to the Superior Court. Next is the Historic District Commission. And again, it's similar. The stuff on the left, that's your Bible. Those are your standards. In the middle is the appeal to the zoning board. They hear it on the record. They can't substitute their judgment for that of the Historic District Commission. Then it goes narrower to the Superior Court in the blue, Supreme Court on the dark blue. I do want to back off the one thing. You probably, maybe you can read it on your screens or not, but under the Historic District Commission there, the second paragraph there, it's 2, says publish standards as necessary to inform historic district residents, property owners, and the general public of those criteria by which the commission determines whether to issue a certificate of appropriateness. So this is a case where, although there's 1, 2, 3 below that have standards. Oh, I forgot I've got my cursor here that talk about it. There's this thing here, published standards. And in Rhode Island, anyway, all the historic district commissions use the Secretary of Interior, the United States Department of Interior, the Secretary, it's called the Secretary of the Interior Standards. It's actually the National Park Service, which is under the Secretary of the Interior, and they publish various standards for historic preservation, for historic rehabilitation, for new construction. They publish standards, and those are the standards which most all of the historic district commissions have adopted. Those are more detailed, and those are the ones which they follow as they're doing it. They do have the power to amend it, but you've got to be very careful to amend it because it needs to be defensible. If you're using the National Park Service national standards, you're pretty well sure that the standards themselves are defensible. It's only your application of them that you need to worry about. So, and then this is just an example of this is the Riverfront Commission with Pawtucket and Central Falls on the border. And again, this is a separate one. It's actually pretty much the same thing. The box here on the left, this is their particular standing. It'll say required findings. This is what they have to find. Then there's an appeal process, and it goes to the zoning board, and it talks about the same procedures as appeal from the planning commission. So that means it's going on the record and not substitute its own judgment. And then it goes to the Superior Court in the same way. So the process is very similar, with just a few little twists and turns along the way. So, should we take a break now for questions? I don't. CJR, again, I got.
Yeah, I think we can do that, Andy. This is where we wanted to stop, right?
Right, yep.
Yeah, we've been running a little early on all of our talks anyway, so we can just end the date earlier, and don't think anyone's going to complain about that.
Sure.
Okay. Well, or we could have lots of questions too. I mean, I have found in my experience with this that the question, this is why I think we're running faster, because it's the give and take of the questions of the live sessions that really help. So,
sure. We weirdly don't have any questions yet.
Wake up, people.
So if anyone has a question thus far, please go ahead and type it in right now. I'll give you a minute here. I think it's best if you use the Q&A function. But if for some reason that's giving you trouble or whatever, you can use the chat function too. That's fine.
There is somebody talking in the background. We got somebody with a mic open.
I think that's me.
Oh,
Yeah.
sorry.
So, no, that's okay. I'll mute when I'm not speaking here.
We all have problems. We're at home and we have other people. My family's unhappy at me for kicking them out of the house. I
Yeah.
suggested to my wife and daughter that maybe they go shopping this afternoon.
So Andy, we do have a question for you here.
Okay.
It is define hardship and more than a mere inconvenience. So kind of the difference.
Oh, sure. Great. Okay. I'm actually going to expand a little bit. So for basic zoning board stuff, there's 3 different kinds of relief that a zoning board would give, as opposed to a hearing an appeal. So if you would, the least degree of difficulty in obtaining is a special use permit. That's where a zoning ordinance says, we think these uses should be allowed in these particular zones, but we want somebody to take another look at it. We want the zoning board to take a look at it with notice going out to the neighbors. Gas stations are very frequent. There's a classic example of, well, gas stations, we do want to have them in this zone, but there's a lot of stuff, so traffic and fire safety, and so let's have that before the zoning board. Sometimes it's also a way for town council members to wimp out. It's something they want, but they don't want to take the heat, so okay, we'll give it to the zoning board to do. Let them take the heat. And zoning ordinances should have standards specific to each special use permit, as well as general ones. And if people meet the standards, they don't have to show any hardship at all. They just have to show that they meet the specific standards. And the general standards is that in the law, it talks about benefiting the health, safety, and general welfare. But the courts have said you don't actually have to prove a benefit. You just have to prove that you're not going to harm the public. You're not going to harm the neighboring properties. You're not going to significantly devalue them. You're not going to have any physical life safety issues, things like that. That's the essential standard for a special use permit. Do no harm. If you'll do no harm and can meet the specific standards, you're entitled to a special use permit. Then on the other extreme, we have what's called a use variance. And a use variance is when someone wants to use some property for use that's just not permitted. Classic example is this is a residential zone that only permits single family homes, and someone wants to put a convenience store in this neighborhood, or they want to put a gas station or whatever, or an office in this neighborhood, and the use is just not permitted. And it's interesting because the law provided all the way back going to the 50s that people had to show unnecessary hardship to get a variance. And the courts have defined unnecessary hardship as loss of all beneficial use of the property. And they do mean all. Basically, your property has to be confiscated. No use at all, worthless, by action of the zoning ordinance if you can't have that use. And that's a very tough standard to meet. So in fact, our Rhode Island Supreme Court in the early 1960s, in a case called Viti, V-I-T-I, versus the City of Providence, came up with this doctrine, well, that's only for true variances. There are also these other variances which are less than that, like somebody wants relief on their side yard requirements, or in Viti, they want relief from the number of parking spaces they're going to be provided. And that's not a real use variance. So they should have some lesser standard. And the court invented the standard called more than a mere inconvenience. And between 1963 and 1991, if you had looked in the statute, if you'd looked at the law books before we had it online and just read the statute, you wouldn't even know that such a thing as a Viti variance existed, because it wasn't there on the law. You'd have to look at what the lawyers use. We have these annotated versions, and it has the statutes, and it also tells the cases that have interpreted those statutes, and it would tell you about Viti. So the big thing that the Zoning Enabling Act did in 1991 was create this dimensional variance, basically codifying VD, and said, if you're not asking for a use variance, then you don't need to show loss of all beneficial use. You need to show this hardship of more than a mere inconvenience. It got further complicated. I'm not going to go too far into it because the statute at that point had language about making full beneficial use of your property, and then the court interpreted that in a way that nobody thought they would, so that got repealed. So they went back to just an undefined more than a mere inconvenience. So if you are just looking for side yard relief or parking relief or something like that, that's a dimensional variance. You have to show a hardship amounting to more than mere inconvenience. Now, you also have to do, I don't know if I can, how quickly I can I share my screen quickly here? Let's see, share my screen, PowerPoint, share. So I'm going to go back here to this slide, which you guys are going to get. But here's the standards for the variance, okay? And if you notice, as you get down to the last ones, what I call 9A and 9B, here's the additional standard for the use variance, loss of all of beneficial use, cannot yield any beneficial use. And here's dimensional variance, that more than a mere inconvenience. But somebody has to meet for both of those all the other 4 or actually 8 standards that are up at the top here, including my favorite, which is more than a mere inconvenience. Maybe it's true that someone has no beneficial use of the property. They can't build a one-family house on this particular lot because they're totally surrounded by multifamily or something else. There's just no way they can do a single family. But maybe they don't need to be allowed a 5-family house. Maybe a 3 or a 2-family house would be enough to alleviate that hardship, give them a beneficial use, but be the least relief necessary, which is one of the things that the board has to find here, that the relief to be granted is the least relief necessary. So you need to look at both of those in coordination, those other standards and the hardship. As to a real definition of more than a mere inconvenience, the courts have kind of said it's like pornography. We know it when we see it. But it should be related somewhat to the use. I know we see it all the time in the board. Just because someone has, they bought the house without any children and now they have children and they need more bedrooms and they need to expand, that's not really a kind of legal hardship. On the other hand, houses were built 100 years ago, 150 years ago without garages at all. And now it's kind of a normal beneficial use of a property to have a garage. So if you need to put a garage and that's going to require setback relief for a 150 years old house, that would be more than a mere inconvenience. Although on the other hand, a 3-car garage with a rec room up above it is not necessarily what you need for more than a mere inconvenience. Maybe it's just a plain old 2-car garage that's smaller and lower and causes less impact on the neighbors. So long answer to a short question, and maybe I didn't even answer it. I'll handle follow-ups.
Thanks, Sandy. I know it's a complicated one. So we have some more questions rolling in. So the next one is, if a comprehensive plan has not been updated within the required time frame, can that be pointed to by an applicant as a reason not to comply with its requirements?
I believe not. Comprehensive plans have 2 different sets of approvals. They have to be approved by the municipal government. And then they also have to be approved by the state. And then there are state requirements that they be updated. My view legally is that the comprehensive plan that is adopted is binding on the municipality up until the time it is amended. If it is overdue for amendment, it doesn't matter. It's the law that's still in effect. You have to follow the comprehensive plan that you have in effect at the time. And then the second thing, really the binding on the state, the advantage of having a comp plan that's approved by the state is it does bind the state. So if you have a comp plan that says, we want our main street through town to be a historic rural road with trees lining it and no sidewalks because that's our character of the community, and your plan's approved by the state, that prohibits the DOT can't go in and widen it and put in sidewalks and do whatever they want. They have to comply with your comp plan as well if it's approved by the state. So the danger, if you don't amend your comp plan according to the state schedule on a timely basis, that's the danger. Now the state's no longer bound by your comp plan. But I believe that your zoning board, planning board, town council, everybody else is bound by their comp plan until they amend it properly. I don't know, Nancy, if you want to comment from a state point of view at all.
This is Nancy. From statewide planning viewpoint, that is the counsel that we give to municipalities that call us with that exact question. Your plan is locally enforceable for as long as it's considered to be in effect. Sorry, didn't get the video going. Thanks for the reminder, CJ. Our agency is the one that will review and certify updated comp plan and amendments. But what you have in place, unless you've rescinded it locally, is in effect, and all your boards, commissions, town councils have to follow it. There is a new Superior Court case out there, Andy. The towns of Richmond and Exeter recently sued the state Department of Environmental Management about a project that was supposed to take place in the Arcadia management area. And in that case, after a lot of mediation, litigation, and back and forth, it did come down from the judge. His decision was written to support the local comprehensive plan, even though either town hasn't updated in a number of years. They're in process of doing that. And the state agency was told they need to follow what's in those local comp plans.
Right.
So we're basically saying the same thing. And it does stress the importance of the comp plans to the communities to establish the vision on how they want to grow in the future.
Great, thanks to you both for answering that one. So next question here. Can you explain further what you mean when you say that the appeal board should not substitute its own opinion? Does that mean that the appeal can only be granted on procedural grounds?
Well, this is kind of my usual answer, yes and no. So it's not just procedural grounds. That's certainly a major thing. One of the standards is prejudicial procedural error. Was there some procedural error that was prejudicial to the applicant? Was there clear error? They made a mistake on some aspect of the procedure. They can reverse it if they find there wasn't substantial evidence, which is really exactly what we're going to get into next. So I'm going to hold off on that about what it means. Basically, they can't substitute their judgment because if there was substantial evidence to support the decision, and we will get to that in a second.
Great, yeah, that sounds good. So another question here is, what is the difference between RICR and RIGL, and how do they interact with each other and higher and lower laws?
So I think you're talking about the Rhode Island Code of Regulations. I assume you're talking about that when you say RICR, and RIGL is Rhode Island General Laws. They react, the Rhode Island General Laws are above the regulations. But oftentimes the General Assembly will pass a law and they'll delegate to an agency, okay, you implement it. You know, we think a good example would be the General Assembly decided that there should be uniform regulations on setback from wetlands by development in all the cities and towns. There shouldn't be one community at 150 feet, another one at 50. The DEM has had a minimum, and communities, some had longer than that, and the General Assembly said, you know, we think it should be uniform. But then they tossed it to DEM to come up with regulations that would specifically decide what that number was and how that number would be determined, et cetera. So that's kind of like the, it's in the regs. I don't want to. I don't want to be flippant, but Pirates of the Caribbean, kind of like the guidelines, but the regs are binding. But if there's a conflict, if there's something explicit conflicting, then the general law takes precedence. And if there's a conflict with the state constitution takes precedence over the general laws as well. And just to make it more confusing, there's something out there called the public laws. And most of the time, those don't bother. When they want to give, CJ wants to conduct the wedding of two of his friends. So the General Assembly would pass a special bill authorizing him, giving him legal authority to conduct that particular wedding. Those kind of special bills are in the public laws. But what's also in the public laws are bills that create joint school districts, bills that create water authorities, fire districts, things like that are in the public laws. And the problem is those aren't online, old ones and published. And so sometimes, I mean, people were talking about land trust questions this morning and whether they're subject to open meetings. And that's sometimes land trusts are created by public law. And there may be something specific in that public law that applies. So just know it's something you might need to ask your lawyer about and say, oh, what about the public laws?
Great. So we have two questions that are related. I'm going to try to kind of lump them together here. So if the planning board and town council interpret the comp plan differently when considering solar projects that require a change to the plan and zoning, why does the town council only consider the planning board's decision as advisory? And then just sort of tag on there, we had another question that asked, what about spot zoning changes by a town council to allow large solar arrays?
So we have questions from the Hopkinton contingent. Let me, and just let me disclose, I am actually representing some landowners in Hopkinton next to a potentially proposed solar array. So I do have a dog in the fight. But trying to answer generally, I do believe that the planning board's opinion on the comprehensive plan cannot be ignored by a town council. If they're going to disregard it, they're going to have their own findings and expertise as to why the planning board was not correct. A recommendation, the general thing is a comprehensive plan is, in charge of it's in the care of the planning board to adopt it with the public hearings and so forth. And once the council adopts it, if they don't like it, their role is to amend the comp plan, not ignore the comp plan.
Great, thanks, Andy. So a couple more questions as of right now. If a lot is non-conforming by being unusually small, and the setbacks, for example, would only allow for a 10-foot wide house, what is the generally acceptable size of a house to be considered, quote, least relief necessary?
I don't think there's really an answer to that question of a least relief house. It really depends on the setting where it is. CJ, I'm sorry, when I guess I answer it, you click answer and it disappears from my screen. So, but that's all right. If I move to answer, I just want to have it in front of me here.
Yeah, I'll try to leave it up until we're totally done with it.
Okay, all right.
And Andy, it moves from the open tab to the answered tab. This is Nancy.
Right, okay.
So when you see open, there's one question pending, and then the next tab over is answered, and those are all the ones he has moved over and said that we've answered live.
Okay, but my house question disappeared. My last one says planning board, but that's all right. I can remember that one. Anyway, the thing to do is look at really what's the neighborhood and what's around it. I mean, there may well be cases where a lot is so small that the answer is it's an unbuildable lot. And you knew or should have known that when you bought the lot. And there are a lot of US Supreme Court cases that get into takings. And again, that'd be a whole afternoon, so I don't want to get too sidetracked. But the key language from the Penn Central case is, what was the reasonable investment-backed expectation of the owner when he bought the property? And I often find that's a great question. You're the zoning board. Someone's come in here and bought this tiny little lot. Now they're trying to build it. What did they pay? If they paid $5,000 or $10,000 for it, did they really believe? And a buildable lot in the neighborhood is 100 or 150,000. Did they really believe that this was a buildable lot? No, that doesn't fit in their expectations. So there can be a situation where something is too small. On the other hand, maybe you've got a small neighborhood of little cottages along the water that are all the, shotgun style, long and narrow, that fit in. And, maybe a little 2-bedroom or 1-bedroom cottage would still be the appropriate use of the property, but in keeping with that neighborhood. So it's really a case-by-case investigation.
Great, thanks, Andy. Next question, how much weight should be given to an abutter who is disputing an application? For example, the applicant purchased a lot which is undersized and requests a dimensional variance, but the abutter's position is that the applicant should have been aware that the lot was undersized when purchased and therefore should not be allowed a variance.
Right. Well, I think that ties a little bit into what I just said. I mean, I think it depends on the aspect of it. I think it's different when, like I said, someone buys we see it a lot along the shore. Someone buys a small house along the shore, but it's there, and they want to expand it. They want to go up maybe, or they want to put a garage or something. And I think, sometimes a dimensional variance is reasonable there to do it. Oftentimes, for example, the dimensional variance is, I want to go into the front yard because I want us to go away from the coastal zone and CRMC's restriction, and that's not necessarily affecting anybody. It's not a side yard or a height variance that's going to cut off anybody's view. That might be something that's more reasonable. Again, look at what's already been done there. Certainly, if it's new construction, I know I and most zoning board members have no sympathy whatsoever. If it's new construction, you knew what you're building. Often see this. Someone comes in, they got a lot, maybe they just barely fit the house. They build the house all the way to the very edge, and then a year or two later, they come in with the garage. Or more sympathetically, they sold it to some poor schmuck who comes in and now wants to put a garage. And we're saying, wait a minute, you built it on this undersized lot and already came in and got the variance for it, or you didn't, you built it to the very edge before. And that's when we go back to those sections again. One of the other things is that it not be a self-created hardship. So that would be a good example of a self-created hardship where someone has come in and buys it and should know about it. So it has to be judged on at each time, but it's certainly a good argument that people should know when they're buying. They shouldn't count on being able to get these variances.
Thanks, Andy. So we have one more question here. The council does amend the comp plan by ignoring the keep residential areas residential part of the plan and talks about other parts of the plan that does not refer to residential objectives. Who is right?
I try to answer all these questions as honestly as I can, but I got to duck this one. I'm sorry, because I'm just too closely or may closely be involved in that. So I don't think this is the proper setting for me to tell you what I think, whether the council or the court was right on a particular thing. I got to keep it to hypotheticals. Sorry.
Sure, I think that's fair, Andy.
What's this one?
Yep, so this one, another question here says, I've seen a lot of dimensional variance requests for in-ground pools on agendas. How can it be argued that there is a hardship for a pool?
Well, as someone who has also argued against them, my personal feeling is I agree. that in general, there's no hardship to not having a pool. My real thing is people who have waterfront property with beachfront access, and they claim that they need to have a swimming pool and therefore need to exceed the lot coverage requirements because they got to have a swimming pool. So I'm very skeptical of it. Being a lawyer and being able to argue both sides of it, I'd say, let's say you're in a neighborhood, you're in a different socioeconomic neighborhood of mostly raised ranches and small cottages, and most of your neighbors have pools or above ground pools and not necessarily in-ground pools even, or they do have in-ground pools and whatnot, and maybe you're arguing it there. This is something that's a hardship. I can't afford to join a pool club or travel to the beach all the time, something like that. I can conceive of an argument being made, but I think it would be very weak. I don't think any argument for an in-ground pool would stand up on appeal. Those are the ones that are granted because nobody objects to it.
Yeah, makes sense. Thank you so much, Andy.
Let me just, I'm sorry, I want to just
Sure.
come back on one thing, because this relates both to the pools and it also related to that question about the dimensional variances and too small and whatnot. There are genuine issues. One of those standards there is it's due to the unique character of the property. So big example, very common example is corner lots and a zoning ordinance that requires a front yard setback on any street side. So you got a corner lot or, with 2 front yards, and that zone requires a 25-foot setback for your front yard. I think in those cases, those are the cases where it is very appropriate to give a dimensional variance, even for something like a swimming pool in one of those front yards that's being effectively treated like a side yard. You'd look at it as the whole neighborhood and see how the neighborhood is treating front yards and side yards and which street, make sure it's in character. But that's one of those things, a unique character of the lot, if it's got that requirement. Now, some ordinances don't do it. Some ordinances let you pick where the front setback does, but others say any street is a front yard setback and they have extreme front yard setbacks. So it'd be appropriate to say you should be able to use one of those as your side yard.
Great, thanks, Andy. I think we'll make this the last question for this session. So this last question here is, aren't hardships supposed to only be related to the lot characteristics versus an individual's circumstances?
Yes, they are. And that's, again, why my swimming pool example is not really relevant. I mean, that's the argument can be made, but it's not a proper legal argument.
Great, perfect. All right, so let's take a break. I think if we come back at 2:30, so about 15 or 14 minutes, give folks a chance to stretch and grab a snack or whatever they might need. Sound
Okay.
good? Great.
Thank you.
Sounds good.
All right, we'll see everybody back here at 2:30. Yep.
Thanks.
Okay. Andy, if you're ready, as everyone comes back from their short break, take it away.
Okay. All right. Let's go back to sharing screen. PowerPoint. Share. And play. Nope, that's that. 23. Here we go. Play from current slide. Okay. CJ, you're looking at full size slide? Okay.
Yes, indeed.
Is the decision supported by substantial evidence in the record that addresses each standard for approval? And this is, in a way, answering that question about what an appellate board, whether it's going to be a superior court judge or a zoning board, if you're on a planning board, is going to look for when they look at the record of your decision. Now, there's a little thing here in best practice tip. and we got to change it. This is kind of hidden among all the other best practice tips. There's two most important things that I want everybody to take away from today's presentation. For those of you here this morning, or those of you who weren't here this morning, it would just be to remember to never use reply all. Don't use reply all in any of your correspondence between board members and whatnot. Avoid it entirely. It just leads to incredible amounts of trouble with open meeting acts and bias and all sorts of procedural issues. The second one is this one here about decision, and it's the word because. I'm sure many of you do decisions. You have a list of standards. You might have a little guideline or cheat sheet or outline of how to make the decisions. And maybe not anybody here, but there's still a lot of people out there who will start with, we find that there are unique circumstances to the subject lot. We find that the applicant will suffer a hardship amounting to more than mere inconvenience if this is not granted. We find that this is the least relief necessary. Those are not findings of fact. Let me repeat that. Those are not findings of fact. Those are just a mere recitation of the standards, to quote one of the Rhode Island Supreme Court decisions. A finding of fact absolutely, positively has got to have the word because or a synonym to the word because in it. You've got to link that standard that you're applying to the particular application in front of you. Why is there more than a mere inconvenience hardship for this one? What's unique about the particular lot? Why is this the least relief necessary? Those have to be there in your findings of fact. I talk about it, we write English from left to right. So your finding of fact has to have the word because, and it needs to have something on the right side of the word because that links it to the particular standard. So we'll talk more about how you do that and things as we go on. But if you take nothing away from this afternoon, I expect you to have that. If I run into you 2 months from now in the Stop and Shop and say, what did you get from the afternoon? I expect the word because. All right, moving along to the next slide. So this is a decision supported by substantial evidence? So what's substantial evidence? So this is a fun one. Our Rhode Island Supreme Court has decided substantial evidence as more than a scintilla, but less than a preponderance. What's a scintilla? A very insignificant or trifling item of evidence. What's a preponderance? The great in amount, weighter, essentially 51% is the preponderance of the evidence. So what this means is there has got to be substantial evidence supporting your decision, which means there's got to be more than a scintilla, but there doesn't have to be 51%. You as a board, when you're weighing it at the first instance, you don't actually have to say, oh, well, we weigh it, it's 51-49 this way, and that's how we rule. There just has to be something more than that, 5% or 2% of a scintilla. There has to be something to base the decision. And you get the job of deciding the facts and weighing credibility. I don't think, I'm going to talk about weighing credibility now because I don't think we talked about it before, although it was touched on this morning a little bit with experts. But so you'll notice that the appellate body, whether it's the zoning board from a planning board appeal or the superior court from an appeal, they can't substitute their judgment on the facts. The superior court can substitute its judgment on issues of law. Superior court decides issues of law de novo itself. But on facts, they're supposed to believe the fact finder. It's the same thing with criminal and civil law. If the jury believes you or believes one expert, it takes an awful lot for any appellate court to say, we're going to decide against that. These people had this person in front of them. They got to look him in the eye, hear what he had to say, see the supporting evidence, and judge the credibility. So those are important decisions. And when you come to an expert witness, it's important. First of all, let's talk about if you have two expert witnesses and one says black and the other says white. And believe it or not, this can happen. In South Kingstown one time, many years ago, large subdivision, one expert witness was a professor at Rhode Island. And he talked about the nitrate loading of the soil and whether it was going to have a harmful effect from the septic systems. And he said it would. And then a University of Connecticut professor came in and said it wouldn't. And by the way, they both used the same reference book for their arguments. As far as I could tell, the only difference between them was one was using English system and one was using metric. So that's why you couldn't match up the numbers. But under oath, they came to different conclusions. So that's a question where the board had to judge their credibility and decide, who do we believe? Which one of these two do we believe? And that's a sort of case where no appellate body is going to be able to overrule you. If you have two equally valid arguments in front of you, it's up to you to make the decision, and that would be substantial evidence. And even if the other one was wrong, they couldn't say it. Now, if they're not equal, that's another thing. Talking again about expert evidence, traffic is one of those things that you need to be an expert witness in to talk about traffic counts. And the example I give, sometimes people try to bootstrap. Oftentimes we'll have police officers. And my analogy is if you're just, if someone's a police officer who lives in the neighborhood and has been on the force for a couple of years, doesn't have any ability to talk about traffic as an expert. Someone who's been on the force and has been the accident investigation and traffic officer for the department for 5 years and has attended a whole series of advanced courses on traffic can speak as a traffic expert. So those are the things, and those are the things that the board needs to do. And the board needs to judge that and make its findings set forth in its decision, as we're going to talk about later. If you don't believe a witness, you got to tell why in your decision, or else that's going to be an error. The court's just going to see, oh, there was this witness here and he talked about it. That's more than scintilla. How come you didn't grant it? You've got to put in your decision why you didn't believe a particular witness or why you did believe a particular witness. But the court can't decide and say, oh, no, you were wrong. It wasn't 60-40 one way, it was 60-40 the other. If there's 40% there, that's enough for your decision and it won't be disturbed. Sorry, let me go down here. So next part of that sentence is the decision supported by substantial evidence in the record that addresses each standard for approval. So this is important of getting things in the record. You need to make the record clear so that everybody in the future can understand what you were trying to do. Whether that is going to be an appellate judge, hopefully not, or if it's going to just be some building official or zoning official 10 years from now trying to figure out what happened, or 30 years from now, you need to get this information in there. So the record is a compilation of all the information received regarding a land use request, including the application, attachments, plans, photos, studies, staff reports, advisory opinions, testimony, and evidence. So I'm just going to take a moment here to talk about photos, both if we go back to in-person and also virtual with Zoom stuff. So first, let's talk about in-person. You're at the meeting and someone comes up and they have photos on their cell phone and they want to show them to the board. The problem is, how do you get them in the record? Oftentimes it's an objector. They didn't know ahead of time what was going to be said. They're there. You could pass the cell phone around, although I don't know that we'll be passing personal objects like cell phones around in the future. But that was what we used to do, pass the cell phone around so each board member could look at it. But also, before that's done, make the person who's testifying email that photo to your zoning officer or your clerk or her secretary of the board or whoever right away. So then you have it in the record. So it's not just Mary Smith showed a photograph to the board and the board was persuaded. Make sure that photograph is emailed so it gets to be part of the record. Now let's talk about what we do today with Zoom stuff and getting stuff into the record. One of the things we do is that we really push, and you should be pushing, applicants absolutely should have a deadline a few days before your meeting when they have to get everything into you. No more walking into the hearing with revised plans the night of the hearing. We've all seen it. We've often allowed it, but that has to end in this climate with Zoom meetings. They've got to get the stuff, you decide how much of a convenient time you need to get it up online, but it should be at least a couple of days before the meeting that it's online, and then whatever before you need it, so that the people who are looking for this, since they can no longer go into your office to look at the plans, they should be able to get this online. And if you think about it, in the end, to the extent that this keeps going long past COVID-19, this is going to be a lot more convenient for everybody. It's going to be more convenient for you without having a crowd of people coming through your office, and it's going to be more convenient for them that they'll be able to get it online. So that's what the towns we represent are doing, making sure that the background material, the application stuff that was submitted is put on the website and available. And as other stuff comes in, that is too. If something comes in, a letter from DEM or a letter from DOT or an engineer's letter, all that stuff should get online. Now the question is, same thing with the objectors. If you know they're objectors ahead of time, if they're represented by attorney, they should be told the same thing. They have a deadline to get stuff in. The problem comes when you get to the hearing itself and people, either didn't get the message. You've got unsophisticated people who want to submit exhibits at the meeting and you're on Zoom, or you've got people, objectors and say, well, I didn't know what they were going to say, so how could I prepare for it? So I think there will be times when you're just going to be continuing meetings to allow it to get that evidence. My rule of thumb so far has been if somebody's got it available to share on their screen, then I would take the same thing as the photo on the cell phone. Email it first to the secretary or staff or whoever the host, and actually maybe the host can share it. And the further requirement that thing that's going to be introduced for the very first time at the meeting has got to be something that can be digested easily. If you have a one-page landscaping plan that you want to show us on the screen that you're introducing the night of the hearing, I'm much more sympathetic than that to a 40-page traffic report. There's no way that we're going to digest a 40-page traffic report, actually even in person, but certainly not on the screen. Or if you have a whole new set of 10 pages of plans, no, that's going to have to be continued because showing them on the screen the night of the hearing is just too much. I think that's a judgment call for each board at the time, but that's kind of my general rule of thumb of what to do at this point. It's important, though, that you give the people time to do it. You don't want to have a denial of due process and not allow people to get their evidence in. So if you have someone on the Zoom call who got their pictures developed at the drugstore but still wants you to see it, then you may just have to postpone it, and that person can drop them off at Town Hall Dropbox or mail them, and then the town planner can scan them in and get it uploaded, things like that, to get all of the evidence on the record, because that's what you want. The record should be everything that you did consider or could have considered in making your decision. Excuse me, gotta move over here. Some best practices. Record should include the application, description of the area, all the maps, plans, drawings, etc., any state agency stuff, pre-hearing, all the staff reports, excuse me. We suggest relevant portions of the comp plan or specific plans or regulations. This is not something that's required, but it's just a best practice. If there's like one key section of your ordinance that really applies to this, have it in the file of the record, make it easier that people don't have to go chasing it. When you get to the hearing, excuse me, any information from the site inspection, if people took videos while they were walking around being submitted, or photographs from the site inspection, records of anything that was mailed, notice, orders, advertisements, the oral testimony given at the hearing, either recorded or with a stenographer, and consultant reports, all admitted exhibits, relevant correspondence, et cetera, post-hearing, the minutes and transcripts should go there. Any rejected or superseded exhibits, basically you should keep the file. Even if there were early drafts of things, if they are in the file, they should be kept there. So there's a whole record involved. Draft decisions or findings if they were presented by staff or applicant, and then the final decision as recorded in the land evidence records together with the recording information and proof that the party got out notice. Now, in a way, it might be actually easier to talk about what should you not include. And I'm going to take this time to talk about exhibits and relevance. So the first thing, I think you all know that the rules of evidence which apply to court hearings do not apply to these land use, planning board, zoning board, historic district commission, etc. The rules of evidence don't apply. So hearsay could be admitted. I mean, the whole point of having a public comment, we get people get up and they tell us their opinion. In court, people are only supposed to talk about facts. There's a traffic accident, someone is supposed to come in, and if you're not an expert, you can say, I could see that the light was red, or I could see that the light was green. You're not allowed to say, well, I think the lights take 8 seconds to change, so I think it was green. You can't say that. You can only testify to what you actually saw with your own eyes, with your own senses. And then experts, and that's where experts come in, they've got people qualified due to their education or experience that can talk and give their opinion and can say, well, I studied this light and I studied the number of seconds and the cycle, and I looked at the photographs and marked out the speed on the ground that the cars were going, and in my opinion, the light was red when the car went through the light. That's the difference. With zoning and planning and stuff, people, you know, even though it doesn't have weight, we do get people who talk about drainage and all sorts of issues that, and traffic, and that's their right to have their testimony. But you have to give it less weight if it's lay testimony, if you have expert testimony on the other side. And the other thing is exhibits. People want to introduce all sorts of stuff as exhibits. Oftentimes newspaper clippings as exhibits, which would never be admitted in court. And the general rule is admit everything. As a general rule, better not to create an issue for due process that someone's witness exhibit wasn't allowed in. And the common language is, all right, we'll admit it and the board will give it the weight it deserves. Now there's two lawyers, somebody goes to put an exhibit in and the other one objects and says it's not relevant. That's what the chair should say. Well, we'll admit it and we'll give it the weight it's deserved. The one kind of exception is, well, I'd say two exceptions. First of all, anonymous correspondence, I don't feel should be in the record at all. If someone sends you a hard copy letter that's anonymous, or if they send an email that's anonymous, I don't think that should be in the record. I think it should be in the file. You can have it in a separate part of the file that's kept separately. It's not provided to the board members. It's not the record. If it's anonymous, it doesn't count at all. The second thing is, sometimes we do have things that are really bordering on defamatory, that people try to introduce either in letters or newspaper clippings and things like that. And I think sometimes it is appropriate that a board should just say, no, we're not going to admit this exhibit. It isn't It's not a relevant exhibit and it's defamatory, it would be prejudicial. So that's the sort of thing. The basic answer is everything else, throw it in the pot, have it there as part of the record. Better to have too much than too little. So next part of this sentence. Oh, that worked with the wheel. Is that? Oh, okay. Is the decision supported by substantial evidence in the record that it addresses each standard for approval? So here we go back to those standards of approval that we were talking about, where I had you those pages with the green and the blue and each standard. And Rhode Island law, you've got to apply each of the standards. And they must appear in your local zoning ordinance. And I guess we could add to this part of the bottom, or if it's an HDC, they must appear or be referred to in a municipal's local zoning ordinance or subdivision land regulations, because the Secretary of Interior standards wouldn't appear in your particular things. But these would be what I call the Bible for each one of those particular standards. And I am just going to run back here for a moment just to, and I understand you don't even have this yet, but these are the things here. These are your standards for your zoning board. These are your standards for your planning board. These are your standards for your historic district commission. And this was the Riverfront Commission. So these are the things that you need to go through each of them and come up with your because sentences that apply to them. And hang on, I'm just going to come back here to this one here. And the next one, sorry. So planning and zoning boards, when you've got the decision to approve, you've got to show that each and every standard has been met and found in the record and must be stated in the decision. If you're going to deny, you don't have to find that each and every one has not been met. You just have to say that they haven't all been met and specify which ones have not been met and why they haven't been met. It's a little different for the historic district commissions. The Secretary of the Interior standards, they don't necessarily have to find all of them because, in fact, they're different things. They really have to apply which of those standards apply to the particular application in front of them. It's also different, as I mentioned, in low and moderate income housing because they have different sets of standards for approve or deny. But whatever it is, you got to go down your list and you got to make it clear about why they apply to the particular thing. So for example, again, I'm sorry, I'm going to run back here. So I'm still leaving. So if you've got your zoning board and you're doing it and you've got to say, okay, we're granting this variance because the hardship is due to the unique characteristics of the subject land or structure and not the general characteristics of the surrounding area, because it is located on a corner lot, which requires a front yard setback, which is much greater than the normal side yard setback for both of those lots. And two, that the hardship is not due to a physical economic ability of the applicant, accepting the physical disabilities in that other subsection, which, by the way, that's if that is a valid thing. That was a law was amended some years ago. That's the one thing where a hardship can go personally to the residents, to someone there, rather than to the real estate. For example, you know, if they need to have a first floor bedroom or something because it's got to have a ramp access for someone who's in a wheelchair, there are various things there. But if it hasn't been, if it's not relevant, you can say it's not due to the physical economic disability because there was no testimony as to physical or economic disability. That the hardship does not result primarily from the desire of the applicant to realize greater financial gain. And this is always a tough one because almost anything you would grant as a zoning board would allow some financial gain because it's going to be an improvement to the property. But the question is that primarily for the financial gain, or is that primarily from the other standards, which you're going to get to too? That it will not alter the general character of the surrounding area because the surrounding area already has most of the houses on the surrounding area are aligned with Street A and therefore have smaller side yard setbacks and have accessory structures such as this proposed swimming pool in their side yard. That the granting of the variance will not impair the intent or purpose of the zoning ordinance. That's one of that's one of the more wishy-washy ones. But again, if you can relate it to the hardship because of the multiple front yards, and the intent of the ordinance is to allow pools in side yards, and this is appropriate as a side yard, particularly because the street it abuts is a paper street. Whatever the reason is, this is what you've got to get out there. That the granting of the variance will not impair the purpose, spirit, or intent of the comprehensive plan, as we're going to find your comprehensive plan, because comprehensive plan considers this to be a residential neighborhood, and there is nothing not in keeping with a residential neighborhood with a swimming pool, if you're approving it. And that it's the least relief necessary because the applicant requested a 20 by 30 swimming pool, but the board is only granting a 15 by 20 swimming pool to be more in keeping with the neighborhood, and therefore it's the least relief necessary. And then getting on to the hardship, and obviously the swimming pool is a hard one on the hardship, but I started down this example, and so I would follow the fuzzy one as well, that most of the property around it, and it's a reasonable use of the property to include the swimming pool within the side yard. Other examples are like, my other example is the property that's got a big granite ledge stuck in part of their yard, and they have to get relief from the side yard on the other side. Hardships can be also specific to a particular building that can be very unusual. Sometimes you might have a much larger building than every other building around it, and there's no way it's going to work as a single family. Those are various hardships that would come in there. But the point is, you need to address these standards. And if you deny them, you need to deny them to get the standards for denial as well. And this is hard sometimes because zoning boards require a 4-to-1 vote to grant a variance or special use permit. And maybe you have a 3-to-2 vote to grant. Well, then in that case, the decision is denied. But maybe the two people who voted no didn't say why they were in fact voting no. And that's where you, when I talk to you being our audience today, you're the sophisticated ones. If you're an attorney or if you're a staff person to one of these boards, you got to tease it out of them right then and there. Don't let them go further with the vote. Make sure right there and then you get the findings out of the people who voted no. Or maybe if you're one of their fellow board members, well, if you're one of the ones who voted no, make sure you explain why. And if you're one of the other board members who voted yes, hopefully still do your part and say, could Mr. Smith and Jones please give their answers for their rationale for voting no? And that's at that point where they should give the causes why they didn't think the standards were met and why they were voting no. CJ, I don't know, again, I'm not looking, I've got the full screen so I don't see the questions. I don't know if you want to take a moment for some questions before I go on to the end, or?
We certainly can.
I know we've covered a lot of heavy stuff before we're gotten on to more of the other stuff about it, more the nitty gritty.
Yeah, you know what? I'll read. Let's do some. We only have a handful, so let's tackle.
Okay,
them.
good. Okay,
Yeah.
good. All right.
So first, the oldest one here. The first question asked was, "What defines an expert witness?"
Okay, good question. An expert witness is someone who has either experience or education or some combination of that to render an opinion testimony as opposed to fact testimony. So a good example was anybody, you don't have to be an expert witness to say, I go by every day and I see a big puddle of water there. You do have to be have a license in engineering to say that puddle that I see every day is coming from property A and not property B. So that's the difference there. And then again, the criteria, is someone a licensed engineer? Is someone a licensed real estate appraiser if they're talking about real estate values? Traffic, I already talked about. It's really that, and it's quite appropriate. Ideally, whoever is testifying should submit a resume that shows it. Historic stuff, we've had people, someone comes in and they've qualified themselves and say, I have a bachelor's in history, I have a master's in historic preservation from Roger Williams University, and I have a PhD in museums, historic museums from this place, and I have done this for 5 years, and I've worked here for 10 years. And then it's up for the board to decide if they'll accept it as an expert. Now, it differs. Some places the chairman makes that decision. Other times it's the board as a vote. It doesn't really matter which way, just, someone does it. And you should also feel free to question that person. Sometimes you have a very experienced person who has no knowledge of the particular situation too. That's part of the question. Well, what do you know about this one? What have you examined this one? Have you ever been to this particular site? Or are you just an expert in theory? So that's what makes an expert.
Great. Next question here is, what's the valid argument for not allowing last-minute plan changes, i.e., if an applicant pushes back when the board says they don't want to accept plans that were changed just before the meeting?
Well, I think that, I think they could have done it when things were live as well. But it's much more so now that it's just not fair. It's not due process for the other people that they can't have an opportunity to see it. Now, ideally, you just say, so we're going to continue this. And if you're at a planning board or HTC thing where there's a time clock running, you ask the applicant to extend the time so that you can continue it. If they won't, you could be in a situation, well, we're going to deny it based on the old plans that you provide, and you haven't provided with a timely notice. We all do have guidelines and so forth, or we should, about when their plans are supposed to be in, which usually are, 3 or 4 weeks beforehand when they're getting scheduled for the meeting. But we're human beings. It's a small state, small towns. We tend to be, accommodating to people when we can. But I just think these days, with electronic stuff, it's harder to do that. It's easy, in a way, it's harder and easier. It's easier if they do bring it in 3 or 4 days beforehand so we can get it up on the website and everybody can see it. It's easier than if they had just dumped it on the desk of the planner on a Friday afternoon and no one saw it till Monday afternoon. It's easier if we can get it up on Friday for everybody to see. It's harder because if they don't do it, there's just no choice for people. One of the great things about Zoom, I think, for due process is people don't have to sign up. They don't have to register. I can't do, Google Teams or some of the other GoToMeeting unless I register. Even if there's no cost, I have to give my email address and information. Zoom, you can just call in on a phone number. Even today we have anonymous people and first names that we're seeing here. You wouldn't send them invites, so that covered it. But people can be anonymous on Zoom as they'd be at a public hearing. If they walked in, we let everybody in the front door of our hall and inside our council chamber. And if they sat down on the back bench just listening, it's the same as if they called in. But because they called in, we have to be especially sensitive to make sure that they have the due process rights to see the stuff. If we want our Zoom hearings to be upheld as constitutional right now, and if we want them to continue in some fashion in the future. I'm just going to go ahead. You get a question. I just got to move one thing in the meantime.
Okay, sure. So next question is, are there requirements that the record be kept on paper? Is having everything electronic acceptable?
Does that mean, kept on paper? If you'd asked me before this crisis, I would have said zoning boards, you got to have a stenographer there taking it down. The fact of the matter is, you can't do a stenographic record of an audio taped meeting because people don't identify their names each time. The stenographer usually doesn't recognize voices. The whole meeting ends up being the transcript being voice number 1, voice number 2, voice number 3, voice from the crowd, inaudible. On the other hand, from a video recording of a Zoom meeting, presumably you can create a good transcript after the fact if you had to. So I'm getting to the point that for other than zoning boards, you could go with just recording and save your Zoom recording and then have it, a stenographer could sit and watch the Zoom recording and effectively transcribe it. It's not as good, but it's a possibility. Best thing is to have a stenographer present. And as I mentioned this morning, make sure your stenographer is a panelist and not muted and has the ability to interrupt people so she can correct them, tell them they're going too fast, don't talk over one another, get their names right. But that's the best thing. And usually stenographers don't cost that much to take down the meeting. And then if you have an appeal, you can require the appellant pay for the actual transcript, which is what costs the money.
Great. And our last question for this little question break is, can you comment on the practice of allowing the lawyer for the prevailing side to write the decision for the board?
Yes, I'd be happy to. I was going to address it later, but I'll deal with it now. So first off, one thing is always the board's lawyer can draft it. And not only is that something that is permitted, this was actually going to come up on my very next slide. The Rhode Island Supreme Court has actually encouraged and recommended communities. There's a case that says, we think all towns have adequate legal counsel, they should avail themselves of this legal counsel to write the decision. Now, the other alternative is asking the prevailing party to write the decision. And that is done in some of the cities. It's done in court cases as well. And I think it's okay so long as it's open and upfront about it, that people know about it. It's not the lawyer writing the decision and slipping it to someone to have from him or her. It should be, here's my proposed decision. I'm submitting it to the planner or whatever. If it's a planning board decision, here's my draft proposed decision. If I know there's opposing counsel already that we've clashed with, a copy should go to them right away. That becomes public, that draft proposed decision. And then the zoning board takes it up, or the planning board takes it up. And maybe they like it and just approve it. Maybe they don't. More likely it's somewhere in between. They like parts of it and not parts of other, and they change it. So I think it's perfectly acceptable and sometimes helpful in some of the communities that don't have the same full-time staff and legal backup to do it, as long as it's done up front. Okay. All right. So I will go back to where I was. Oops. Okay. Next, best practice. Yes. So who drafts the decision? So I've already talked about having other counsel do it. And as we talk about it here, if at all possible, have it done. By the way, there's a big typo in number 2. Decision should be drafted by municipal counsel. That counsel should be spelled C-O-U-N-S-E-L instead of C-I-L. Ideally it should be done by one of your professional people with a draft reviewed ahead of time or submitted. That's not always the case, I know, and sometimes zoning boards and stuff do it on the fly, but this is the best practice that's recommended if you've got the resources for it. Oops, I skipped one, sorry. Nope, I didn't. Okay. I'm going to basically tell you there's lots of stuff here that you can list and whatnot. Again, most of this stuff is not important. There are 2 things here. One is to make sure that you talk about the latest plans. Make sure your decision is specifying what you're talking about, because plans change over time. Actually, I might have this in the next one too, but make sure you've got that. If plans have changed over time, make sure you actually specify the date and the iteration of the particular plans you're talking about. All of this stuff is kind of fluff, except for this one right here. List each standard and identify the evidence that leads the board commission to conclude that the standard has been met or has not been met. And what does that mean? What is that listing going to have? Every single one of them is going to have the word because. This is your because statement. The standard, and what is the evidence? What is it about this particular application to conclude that the standard has been met? Let's say you're doing a subdivision and you've got the standards on the subdivision, and whoops, okay, that did not work. I thought I could get, I gotta go back here this way. Okay, so here we go. Our land development project subdivision, we've got our standards here. The proposed development is consistent with the comprehensive community plan, or has satisfactorily addressed the issues where there may be inconsistencies. Because goal 372 of the comprehensive plan calls for this area to be developed at low density residential of not more than 10,000 square feet per dwelling unit, and the proposed development calls for low density residential at 12,000 square feet per dwelling unit. 2, the proposed development is in compliance with the standards and provision of the zoning ordinance. Because this is in an R12 zone, and all the zones will be 12,000, all the lots will be 12,000 square feet. 3, there'll be no significant environmental impacts from the proposed development as shown on the final plan, because the property is a flat field with no wetlands and served by public water and sewer. 4th, the subdivision as proposed will not result in the creation of individual lots with constraint to development, because it has both legal and physical access on to main highway. And the traffic report has shown that there will be no harm to the traveling public from the traffic from this development. Oh, I'm sorry, I jumped ahead to 5. 4 was that it wasn't going to result in creation of individual lots behind it. All of the lots are connected to public streets because all the lots are connected to public streets that have access to main highway. That's all you have to do. Go through the standards and give that word because to make sure that everybody knows what they are, in fact, relating the standards to the decision before you. Next one, some more components. Summarize the main details of the application. I'll emphasize the words summarize and main. Don't feel you got to just recite every detail of the application. That's what the record's for. You don't have to. Get the key stuff so it's not confused with something else, and you don't need everything under the sun in the application. For example, describe the other properties in the vicinity and their use and zoning classifications. Really, I don't think that needs to be in your decision other than how it relates to finding standards. When you're talking about that it's not going to impair the intent of the plan or cause problems with the neighboring property, that's when you might want to talk about the properties in the neighborhood and their zoning classification. But I don't think you need to lead off with it anywhere. You should identify the relief approval requested. We talked about that 10 by 22 or 12 by 22 foot deck and the setbacks. You should make it clear what the setbacks are. You also want to make sure, hold on one second. Conditions. If you've got any conditions that you're going to impose, you need to kind of keep track of them. They have a way of getting lost as you go through the process, particularly if you're at a planning board and the application goes for months and months. And, in month 2, the applicant promised that he would provide a separate school bus stop off of the main roadway. You got to make sure someone, it doesn't matter who, someone, whether it's your secretary or, it's probably your planner, is keeping a list of those so that when it comes down to the decision, you can get those back in. And one of the conditions of decision is applicant will provide a school bus stop off of the main road as part of the project, as shown on sheet 7 of the plans or something like that. You want to make sure that you don't lose those conditions as you go through time. Listing the meetings and the hearings as applications is actually fairly important. Zoning boards, it's more important. You've got to have the same 5 members who vote have been present for the entire hearing. But it's a good idea to have that listing and keep track of that. It allows people in the future to go back and check if they're trying to find the records. Itemize the materials in the record. Again, lists are just bullet points. These are helpful, but don't let this take precedence of your because phrases. Ideally, you're going to refer to certain documents and experts and reports as to your because. Like the one I was talking about, we find there's access to the street and it's safe access because the traffic expert testified there'd be no harm, as set forth in the traffic report, which is Exhibit 17, for example. That sort of because statement. So if you're going to do it, put especially the relevant documents in the record as far as an itemization. They're all part of the record, but in your decision, you don't have to itemize all of them. Provide any additional matters of fact that may merit separate discussion, particularly if they were a topic of debate. And this goes for things that are both related to why you grant, or maybe there was a big hot issue of debate that a lot of the neighbors brought up an objection, but that you're not, following through on, and you want to explain why. Maybe that's it. Maybe there are a lot of neighbors, I think we've all heard it, that are all upset with the traffic from this 4-lot residential subdivision, and now their kids can't play ball safely in the street. And maybe I'm too a minor one there, but this is the idea. If you have that, you might want to have something of it. There were issues raised about the traffic. Objectors raised the issue of traffic. However, we are persuaded by the traffic report by Joe Smith, a recognized traffic expert, which showed that there wouldn't be any significant difference to the traffic on the neighbor streets and no harm to the public safety on those streets. If there's some other issue that's particularly relevant, nothing's coming to mind at the moment, but sometimes there are these oddball things. Just mention it. Again, the idea is you want the person in the future, whether it's the historian 100 years from now or the zoning official 20 years from now who's scratching his head trying to figure out why you did what you did, to the Superior Court judge 2 years from now who's deciding whether to overturn you or not. Tell the story. Explain why you did what you did. So there'll be a better chance for everybody to have a better outcome going forward. If you're not accepting the testimony of an expert witness because you don't find them credible, this would be a good point. If you're not actually discussing it as to the finding that they're in, if you haven't put it there, this would be another place to do it. If, for example, you're rejecting their entire testimony, you want to put the reason why. If you're a town council and you're rejecting your planning board's advice on comprehensive plan consistency, you want to put it in great detail and with the basis of that decision there as well. Again, list each standard and identify the evidence that leads you to conclude. Because, that's what it is. Because, as we said, the board finds, repeat the standard, and if it's in the negative, repeat it in the negative, why you couldn't find it. There's a little here note about some municipalities use a whereas clauses. That's fine. If you don't like them, you don't have to. You can just use numbered components or whatever, or bullet points. I think numbers or letters are better than bullet points just so they can be referred to later. And if you're going over and discussing it, it's easier to say for one more member, well, I think number 3 should be changed to this, as opposed to, I think the 3rd bullet point down should be changed. State your conclusions. Again, this is where I talked about specify the relief and list any conditions or restrictions which the relief is subject. Make sure you don't want to lose those restrictions over time. I had a case once where there was someone who was coming in, they were converting a garage, an old auto repair garage, to a restaurant. They came in, they went before the zoning board. They were on a busy road at a very bad curve. They actually had a traffic report. But the traffic study was only done for the morning because their plan was to only open for breakfast and lunch. They weren't going to be open for dinner. So they didn't pay to have the traffic expert do a study of the PM peak of commuters, only the AM peak. And the traffic expert found there'd be no problem from that AM peak. And the board ended up granting the relief. But no one mentioned the fact that it was restricted to being open for just breakfast and lunch. That person who was running it unfortunately got sick, got ill, decided couldn't handle it himself, so he sold it to someone else a couple of years later. They went and looked at the zoning board decision on record in the land evidence records. And they looked at all the conditions. There were conditions. There couldn't be a walk-up window. There couldn't be alcohol sales on the deck. There had to be a fence around the septic system, things like that. There was nothing in the way of conditions about no dinner service. So they went and opened, and they were planning on having dinner service. And that was a question, and I lost, but I should have lost because I argued that they were still buying what was presented before the board. But I should have lost because really those people had no way of knowing what the particular restriction is with due diligence. Is it due diligence? It's one thing to go read the decision in the land evidence records. Is it really due diligence to make someone go and read the entire transcript of the hearing? Now, I will just disclose, there is one Rhode Island Supreme Court case to the contrary, the one that talked about the wood recycling place in East Providence, and basically suggests that, if someone makes a promise to the board while they're there, that they can be bound by that promise, even if it does make it into the decision. But my advice to you is still, don't lose those conditions in the first place. Make sure you get them in the written decision. And it was noted this morning, put them in both the written decision and if you're recording a plan, if it's a subdivision or land development project and you're recording the plan, put them in both places. Sometimes people only go and read the written decision and don't bother pulling the Mylar plans. Sometimes they look at the plans and not the decision. It can't hurt to put them on both particular places. So, components of a sound decision: provide information about the next step. This isn't really something that you as board members have to do, but it's a staff member thing. For those of you in the audience who are staff, you should probably put that. If the decision, if it's a planning board decision and it's got a vesting period, it would be helpful to have that on the decision for the applicant. And you might have a description of the appeal process as well, so that people know when they read the decision where they're going. So, decision should include type of request. Again, all the standards that must be met, and list the evidence again. All I can say is because. That's the key thing. And make sure if you've got a denial that you list the evidence why it was denied. Watch out for those zoning board 3-2 denials. Make sure you get it out of them. If you have any kind of majority, that's a really good thing. If you have a 3-2 vote to grant, that's a really good opportunity to basically, if you're the planner, you're the staff person or the lawyer, say, well, excuse me, Mr. Smith and Jones, could you please put on the record why you didn't, or direct me to draft a draft decision, and I'll come back at the next meeting with the draft decision. So you can get some support, the evidence in there of why the standards, which ones weren't met and why they weren't met, and why the decision was being denied. Sorry. A few more best practice tips. instruct the staff to write a written decision according to the board's decision. We were just talking about this, and it's really important if you have one of those zoning board meetings, but in general, it's a good idea. If you've got the time, if you've got the staff, instruct the staff to do it. And we talk about this may vote to instruct the staff. That's often called a straw vote. It's particularly if maybe the board doesn't know how they're leaning. Maybe it's a larger board, 7 or 9 members of the planning board, and they don't know how they're leaning. You know, you can have a straw vote to see how people are voting, and then lead that to instruct the staff to prepare a draft decision. And that, of course, is unfortunately where you have a situation sometimes where it's split. There's 6 people, 3 say, gee, I think it should be approved, 3 say deny, and you know, staff is writing 2 separate draft decisions for the board to do. It's rare, but it happens. It's still better than not having any decision prepared ahead of time as well. Recommend that it be approved, you know, drafted by staff or the legal counsel or working together. And once it's drafted, you want to make sure it's circulated so that everybody has a chance to look at it, clarify, correct it. If they're doing it, one way to do it is, this comes back to my reply all, don't send it to everybody and have everybody reply at once and start an open meeting violation. But if the staff member sends out, blind copy it to all the board members, and then they can reply just to the staff member individually. And the staff member can coordinate and correlate the comments to be changed. And then at its next meeting, where possible, whoops, I'm jumping here, make any necessary changes and vote to adopt the resolution. So I think that's pretty much it. We have some summary stuff here just of the whole process that we've talked about. I don't think there's much to do. I guess what I would suggest, I know we're getting late and it's a Saturday afternoon, so I think we should go for, if we have more questions. And then the only thing is, and I'll give you this opportunity, if you have questions, for those of you who weren't here in the morning specifically, but anybody if you want, we talked a little bit about ex parte communications and ethical behavior and conflicts and recusals. So if those of you who would like to hear more about that, if you want to ask about those in the questions, even though I didn't cover them in the materials, I'd be happy to talk about, answer any questions on those issues as well.
This is Nancy. We actually are well ahead of our schedule. We had anticipated going all the way till 5 o'clock, so we've got plenty of time for questions. And when the questions are over, I'll come in and do some concluding remarks and go over resources. And then CJ will be our final goodbye and thank you for all the participants today. So let's hit questions.
Great. Thanks, Nancy. And thank you, Andy, so much for covering everything wonderfully as usual. So I'm going to tackle this question first because this was a more recent topic. Should you include the alternate zoning board members in a straw vote?
I would say no. Zoning board alternates aren't supposed to vote unless they're actually activated because less of a quorum. I understand you could have a weird thing where you have, 7 people, 5 and 2 alternates, and 4 out of the 5 regular ones are voting for it and 1's against, and you have a draft motion and maybe one of those in favor doesn't show up and the alternate's against. You could have a switcheroo, but I don't think alternates should be voting at all, even in a straw vote. They can discuss it, give their ideas and thoughts, try to persuade their colleagues to vote the other way, but I don't think they should vote in a straw vote either.
Great, thanks, Andy. So I think for this question, I think we typically have this information available in person with a handout, but for decisions that have a time frame associated with them, what is the date of I think the due date probably of the decision, the date of the board vote, the date of the signed decision, or the recorded decision?
Okay, so we're actually looking at 2 particular things. So for where it's got a time frame in the act, that, if you do not act within this time, if you don't approve or deny it within 65 days or within 45 days, it's deemed approved automatically. It is the date of the vote. That is based on a case with the town of Tiverton, New England Development versus Berg, where the Supreme Court said that. I don't actually, it's a case I won that I don't actually particularly agree with. I don't think it's very logical, because as I'm about to say, everything else we run from the date you record it. So that would make sense to have the same date for both. But our Supreme Court has said for those kind of mandatory deadlines, it is the date the vote is taken, even if the written decision follows days or weeks later. For appeal timeframes, it runs from the time it's recorded. The 20 days or to appeal of zoning board decision, or 30 days or whatever, depending on the statute, all of those start running when it's recorded. They don't start running at the date of the vote, only when it's recorded in the land evidence records. And that at least makes it easier to keep track of. There's an agreed upon date that everybody agrees, here's the starting gate.
Excellent. So the next question is, who is responsible for monitoring a condition of approval when the condition is to be initiated 1 year after the majority of a project is complete?
It really should be the staff. I mean, I guess it depends on the particular project or whatnot, but I think the important thing is to decide up front who that's going to be. And that might be something which you might want to put in your decision. For example, sometimes if it's infrastructure or paving or whatnot, maybe it's the director of public works. But let's decide that. Let's make sure it's there in the decision, and let's make sure the director of public works knows about it. Either is there at the decision. Lots of times DPW directors are there, or town engineers are there at the planning board meeting. Probably better just for the planner or the administrative officer. That's one of his or her responsibilities. They got to put that in their particular calendar. Smith subdivision, check on final code of paving next March. So it doesn't really matter who, so much as you make sure that it's someone, and you make sure that someone who agrees that it is their job to do it. Don't give it to someone who doesn't think it's their job to do it.
Great. Our next question is, as a waterfront commission member, am I free to discuss with neighbors and friends some speculative development ideas which have never had an application submitted to the town?
Okay, so a couple of things here. So I'm going to assume that this is a waterfront commission that has a power to approve things, such as like the East Providence Waterfront Commission, maybe, that they've got. I don't know, it's only a first name, so, but I'm assuming they've got authority rather than just an advisory. But it's pretty much, it's similar. Certainly if you're an approval body, the answer is no. If something's going to come before you for approval, you should not be discussing it outside of the public viewpoint, other than to say, hey, Charlie, the medical office building development is going to come up in a month or two. You ought to make sure you get on the list to get the agenda. Sign up on the Secretary of State's list for the agenda so you'll know when it's coming up, because I know you want to talk about it. But again, you members of a body should not be discussing the business of the body with other members of the body or with the public outside of a public meeting that everybody can hear. We didn't talk about it at all here, but I'll just mention, remember, big difference between a public meeting and a public hearing. All public hearings are public meetings, but not all public meetings are public hearings. A public meeting is what we're talking about here, that the public has the right to hear what's being and see what's being said at the meeting by their representatives, whether it be zoning board members or waterfront commission members or town council members, et cetera. Public hearing is when they've further got some statutory right to be heard with due process and speak their piece. But either way, even with the lesser standard of public meeting, no talking about the public business outside of a public meeting.
This is Nancy. I just wanted to chime up and perhaps make an alternative suggestion. If you're a board or a commission members and you seem to be getting a lot of those type of questions where people are speculating or trying to submit ideas and everything, have a workshop to do that exactly thing that you post as a public meeting. Invite the people to come in, invite them to come in and share their ideas and have a brainstorming session to do something like that. And that way you're doing it and you're meeting the Open Meeting Act requirements. And sometimes people, they like to share their ideas with others, and you can build on that and then incorporate that into your planning process. And it's a suggestion.
All right. Well, those are all the questions that have been submitted as of now. So I suppose maybe Nancy, you can get started with showing us around sea level rise training, and I suppose if we get another question in that time, we can address it afterward.
Sure thing. So if I'll share my screen and I'll take our participants on a quick little tour. Get there. I don't know why that is there. Let's minimize that. What I wanted to do and share with participants is in 2017, the General Assembly adopted requirements, and these are specific to planning boards, that they must educate themselves on the topics of sea level rise, climate change, and flooding. And we have developed some resources for that. So I wanted to show you how to find those resources. And what you're seeing on the screen is my agency's webpage, the Division of Statewide Planning. This is our homepage. And you can look at the URL here, www.planning.ri.gov. That will bring up this page. So to get to the resources and the stuff that I work on, I call it the really interesting stuff, you go over to this little tab, planning areas. Let's get rid of that. Toggle down, natural resources is the section that they charge me with. And you can see the web page changed to this particular page. This is the intro page. There are quick links on the right side of the page. And you want to click on the bottom one that says land use law. And that brings up another page. And this page is references for everything we talked about today in the morning session, the afternoon session. One of the things I do for my agencies is I'm also a policy liaison and make recommendations to the administration for what's going on in the General Assembly. So there's a record of that by year. But this part right here is what I want to bring your attention to, especially if you're a planning board member. The provision of law that said you had to do sea level rise, climate change, and flooding education. And you are required to self-certify on this by filing something with your particular municipal clerk. So we provide you a sample statement that we developed to be able to do that. Basically, you fill in your particular planning board that you work for and that you've done the required education. We've also provided a number of resources to enable you to meet that education. Right here is Prep RI. It's a wonderful resource developed by a Coastal Resources Council, and it's videos. And you can watch, there's a bunch of videos. There's about an hour of separate modules to educate yourself. It's a quick and easy way of doing it. And then for the rest of the required training, there are additional resources, and we've sorted them by category about community planning, flood mitigation, general climate adaptation, green infrastructure, wastewater. And then the rest of the page is links to the live Rhode Island general laws for the enabling laws that you've heard us mention numerous times today. So I just wanted to point this out to all the planning board people that are participating today. If there's any questions about this, you can get in touch with me. If you go to the webpage and there's a staff and committees button here, and it brings up our organization chart. And then if you want to get in touch with us, you can click over here for staff contacts. So that is basically what I wanted to share. I did want to thank everyone for participating today, and especially of those who have held on to the bitter end this afternoon. And I want to thank our trainers, especially for volunteering today and helping us put on these presentations. So I'm going to stop right there, and it's back to you, CJ.
Thank you, Nancy. I'd like to definitely second all the thanks to you, Nancy, and Andy, and Caroline, and Amy from this morning, who isn't here this afternoon. And thank you again to everyone for attending. So again, you'll be getting a PDF of this presentation. I think it's going to look slightly different than the one you saw today, but it's the exact same content. You'll be getting that just in a few minutes. And we will be able to send all of you and to make public eventually a recording of both this afternoon session and this morning session in full. And you can, view it at your leisure whenever you'd like. Just grab a bowl of popcorn on a Saturday evenings, maybe. And really quickly before I forget, as Jen West says in the chat, props to the Narragansett Bay Research Reserve as well for their co-creation of the Prep-RI module. So I think that's it. Again, you'll be getting some stuff from me. We did have a little survey link on SurveyMonkey. If you wouldn't mind filling that out, it should have popped up in your browser. I probably will send a link out later to that as well. But thanks again to everyone. And, you have my email if you need any of these things, they don't come through the right way or whatever. And I think that's it. We did it. So have a great day, everybody. And you'll be getting some stuff from me very shortly. Thanks very much.
Thank you all. Bye.